Good evening, sir. My name is Rapolio. So this is my final exam. Number one, who must prosecute criminal actions under the latest amendments to Section 5, Rule 110. So all criminal actions, either commenced by complaint or by information, shall be prosecuted under the direction and control of a public prosecutor. Number two, when is a complaint or information deemed sufficient? So a complaint or information is sufficient if it states the name of the accused, the designation of the offense, the acts or omission complained of as constituting the offense, the name of the offended party, the approximate date of commission of the offense, and the place under the place where the offense was committed. Number three, what are the elements of a prejudicial question? So there are two essential elements of a prejudicial question. The civil action involves an issue similar or intimately related to the issue raised in the criminal action. Number two, the resolution of such issue determines whether or not criminal action may proceed. Number four, define preliminary investigation when it is required. So preliminary investigation is an inquiry or proceeding to determine whether there are sufficient ground or to engender a well-founded belief that a crime has been committed. And a preliminary investigation is required to be conducted before the trial, before the filing of a complaint or information for an offense where the penalty prescribed by law is at least 4 years, 2 months, and 1 day. And number five, what is investigation provided under Section 7 of Rule 112? So when a person is lawfully arrested without a warrant involving an offense which required a preliminary investigation, the complaint or information may be filed by a prosecutor without need of such investigation, provided an inquest has been conducted. In the absence of an inquest prosecutor, the complaint may be filed by the offended party or a peace officer directly to the proper court. The affidavit of the offended party or arresting officer or person. And number six, define arrest and how it is made. So arrest is the taking of a person into custody in order to answer the commission of an offense, and an arrest is made by the actual restraint of a person to be arrested by submission of the custody of the person making the arrest. So there is no violence or unnecessary force shall be used in making an arrest. The person arrested shall not be subjected to a greater restraint when it is necessary for his detention. So number seven, what is the instances when the arrest without a warrant is lawful? So when his presence, the person to be arrested has committed, is actually committing or attempting to commit an offense, and then when an offense has just been committed and he has probable cause to believe based on personal knowledge or facts circumstances that the person to be arrested has committed it, and when the person is arrested is a prisoner who has escaped from a penal establishment or place where he is final judgment or is temporarily confined while his case is pending, and or a person escaped while being transferred from a confinement to another. And then number eight, what is bail and the kinds of bail? So bail is the security given for the release of a person in custody of the law, furnished by him or a bondsman to guarantee his appearance before any court as required under the conditions herein specified. Bail may be given in the form of corporate surety, property bond, cash deposit, or recognizance, cash bail, federal bail, and immigration bail. And number nine, give five rights of the accused. So one, to be presumed innocent until the contrary is proved beyond reasonable doubt. Number two, to be informed of the nature and cost of the accusations against him. Number three, to be present and defend in person and by counsel to every stage of the proceedings. And four, to testify on behalf last subject to cross-examination on matters covered by the direct examination, and to be exempt from being compelled to a witness against himself. And number 10, how is arraignment is made. So arraignment, the accused must be arraigned before the count where the complaint or information was filed or as assigned trial. The arraignment shall be made in open court by the judge or clerk by furnishing the accused with a copy of the complaint or information, reading the same in the language or dialect known to him, and ask whether he pleads guilty or not guilty. And then number 11, what is plea bargaining? A plea bargaining is an arrangement between a prosecutor and a defendant whereby the defendant pleads guilty to a lesser charge in the expectation of leniency. And number 12, what are the instances arraignment may be suspended? So the accused appears to be suffering from a sound mental conditions which effectively renders him unable to fully understand the charge against him and to plead intelligently thereto. In such case, the court shall order his mental examination unnecessary, and b. the exist of prejudicial question and a petition of review of the evolution of the prosecutor is pending at either the Department of Justice. And number 13, when does double jeopardy attaches? So number 1, a valid information sufficient in form and substance to sustain a conviction of the crime charge. And number 2, a court of a competent jurisdiction. 3, the accused has been arraigned and had pleaded. And 4, the accused was convicted or acquitted of the case dismissed without his express consent. Number 14, what is the order of the trial in criminal cases? So trial can be divided into 4 stages: the opening proceedings, examination of evidence, questioning of the defendant, and the arguments. Number 15, when can a co-accused be discharged to become state witness? So the prosecution should file a motion to discharge the accused as a state witness with his consent. The court will require the prosecution to present evidence and the sworn statement of the proposed state witness. If the court is satisfied, it will discharge the state witness. So define judgment. Number 16, define judgment. So judgment is the adjudication by the court that the accused is guilty or not guilty of the offense charged at the imposition on him of the proper penalty and civil liability. If any, it must be written in the official language, personally and directly prepared by the judge and signed by him, and shall contain clearly and distinctly a statement of the facts and law upon which is based. And then define search warrant. Number 17, define search warrant. A search warrant is an order or writing issued name of the people of the Philippines, signed by the judge and directed to the peace officer, commanding him to search for personal property described therein being it before the court. And number 18, what are the requisites under the search warrant be issued? Number 18, what are the requisites in order that a search warrant be issued? So a search warrant shall not be issued except upon probable cause in connection with one specific offense to determine personally by the judge after examination under oath or affirmation of the complainant and the witness who may be produced are particularly describing the place to be searched and the things to be seized, well, may be anywhere in the Philippines. And number 19, what are the personal properties subject of search and seizure? So what are the properties to be seized? A search warrant may be issued for the search and seizure of the personal property. Number 1, subject of the offense. Number 2, stolen or embezzled and other proceeds or fruits of the offense, or used, intended to be used as the means of committing of an offense. And number 20, what are the qualifications of a witness? So when the accused has been held to answer the offense, he may be upon motion with a notice of the other parties. So the witness shall examine behalf the motion shall state the name and residence of the witness, the substances of his testimony, and that the witness is sick or infirm as to afford reasonable ground for believing that he will not be able to attend the trial, or resides more than 100 kilometers from the place of a trial, has no means to attain the same. So that's all, sir, my final examination.